House Ag and Environment is back from recess. Hope everybody had fun on the swing sets. Want to go ahead and find my place here, folks. I think my computer's sitting on it. Go ahead and reintroduce our Sergeant at Arms in case you need them. And I thought that was there, so bear with me here. Got everybody, but I got about 1,000 papers up here. Got it. Got Ray Cook, Teresa Ferguson, Nina Ledge, and Stafford Young with us again, so I appreciate y'all putting in your overtime. You'll get your check in the mail. Also, we still seem to have our same pages, so thank y'all for coming and working overtime also. All right, we're going to hear 401 PCS that's before us now from Senate. Representative Dixon, if you'd like to go ahead and start.
Thank you, Mr. Chair, and members of the committee. Welcome back. I think it would behoove all of us if we asked Chris Saunders to review the provisions of this bill.
Okay. Thank you, Mr. Chair. Chris Saunders, Legislative Analysis. So I'm going to quickly run through what's in the bill in this PCS. Section 1 directs the Department of Agriculture and Consumer Services to update the strategic plan for protecting agricultural water resources. Section 2 would establish a feral swine working group within the Wildlife Resources Commission to develop a statewide plan to control feral swine damage on private and public lands. Section 3 would allow for denial of special use permits for negative impact on agricultural production. That would not apply where the primary purpose of the proposed land is construction of single-family dwellings or 2, 3, or 4 family dwellings. Sorry. Section 4 would repeal a violation point system applicable to swine farms that was enacted in 1997 but has never been implemented. Section 5 makes a technical correction based on a 2023 change in the law. Section 6 would amend eligibility criteria for the animal waste fertilizer conversion cost share program to provide that a person who's converting sludge from an anaerobic lagoon or other liquid animal waste management system treating animal waste from a livestock operation into fertilizer products is eligible for that program. Section 7 would clarify the species susceptible to chronic wasting disease for purposes of deer farming. So that would allow the importation of muntjac deer and reindeer that were not bred in captivity, as those are defined by USDA as not susceptible to chronic wasting disease. Section 8 would modify requirements for composting of equine and bovine mortality. They would basically have the same requirements for current composting facilities for animal mortality, except they wouldn't have to be on a impervious foundation and under a roof. Section 9 would require school principals to authorize at least 2 excused absences per academic year for participation in equestrian sporting events, livestock shows, or similar agricultural events. Section 10 would declare New Hanover County and Pender County as high hazard counties for purposes of open burning. Section 11 would allow the pesticide board to adjust their annual assessment for registered pesticides up to $125. They'd have to do that by rule. Section 12 would give the Department of Agriculture more authority to enforce under their liquid petroleum gas inspections. Section 13 would make changes to the Public Waymaster program. It would make a license valid for a calendar year versus the year running from July 1 to June 30th, and change some fees, make some changes to the seal and how they can use electronic stamps. Section 14 would direct the Agriculture and Forestry Awareness Study Commission to study low-hanging communication lines. This was enacted back in 2024 as well, but the commission didn't actually meet and study that. Section 15 would reduce some penalties for certain shellfish aquaculture violations, namely improperly marked shellfish lease areas and operating under expired aquaculture operation permits or shellfish lease agreements within 1 month after the expiration. Those would be a warning ticket for the improperly marked shellfish lease area. A second offense within a month would be an infraction, and then a third would be a Class 3 misdemeanor. Currently, those are Class A1 misdemeanors. Section 16 would increase the penalty for second or subsequent offenses for larceny of crops. Section 17 would provide that in a products liability suit based on a failure to warn claim, the duty of a manufacturer or seller of a pesticide to warn about the risk associated with that pesticide is presumed to be met if the label has been approved by EPA under FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act, and the pesticide is registered with the Pesticide Board. That section would specify that the presumption may be rebutted only by showing that the weight of the scientific evidence does not support the scientific basis on which the required warning is premised, and that the manufacturer or seller knew or should have known at the time that the pesticide was sold that the required warning was not supported by the weight of scientific evidence. Section 18 would add small or large type 1, 2, or 3 composting facilities under the definition of agriculture in 106-581.1. Section 19 would increase the amount of the assessment on propane from 0.002 to 0.003 cents per gallon and increase the vote share required to approve the assessment. Section 5.1 would make certain rules that the EMC was required to adopt after approval by US EPA last year, exempt from the 10 letters of objection and legislative review process. And then Section 21 gets into the disaster recovery funding portion of the bill. That would appropriate $20 million in non-recurring funds to Robeson County for state matching requirements for federal funding for Lumber River storm debris cleanup. And Section 22 would appropriate $142 million in non-recurring funds for statewide crop losses due to verifiable losses from an agricultural disaster in 2024. And that is the bill.
All right, thank you, staff. Any questions for staff? Representative Harrison.
Thanks, Mr. Chair. I have a couple of questions. I was making notes as you read through them. If I could start with, please, Section 3, the denial of special use permits for negative impact on agricultural production. I'm just trying to figure out what that might be. So it's allowing for single-family homes, but does that mean like it wouldn't allow for, I don't know if solar panels get a special use permit or what we're talking about? Chris, are you able to help me on that?
Staff.
Mr. Chair, solar panels would likely be a use that would be affected by that, yes.
All right.
Thank you. And also then, I think I'm jumping over to the shellfish aquaculture. We just passed the first, second reading, House Bill 926, that had a provision related to penalties on shellfish aquaculture. Is it the same?
Go ahead, staff, for a series of questions.
Representative Harrison, which bill did you say?
926, the reg reform bill. It was the last bill we.
I think this did make it in there.
Okay.
Let me check real quick, and I will let you know.
Thanks. And I also want to ask about the APA rules related to wastewater permitting, modernizing. And this might, if you could help this in the context of House Bill 402, which I think changed the 10 letters of objection, or maybe House Bill 402, the RAINS Act, went back to the way we're doing it now. I'm just wondering why this specific area, and will it matter anyway if 402 gets enacted? Did we change that about the 10 letters of objection in House Bill 402?
Mr. Chair. So Representative Harrison, the RAINS Act does not change the 10 letters of objection process, and you know I I can't really speculate on why, but I will note that these rules have to be approved by US EPA. They can't be adopted until they're approved by US EPA. So I think maybe the thought process is that they've already been reviewed. So, you know, there would be another layer of review on top of that, if it were subject to the 10 letters of objection.
Got you, thanks. And Mr. Chair, just one more quick one, because I
Okay.
assume the pesticide section will get,
After this, we're going to defer to Representative Dixon to talk on the bill, and then we'll take more questions from the
sure,
committee.
okay. So just one quick one on the $20 million in section 21. The $20 million that's allocated to Robeson County, was that money coming from the blueprint, or is that someplace else that blueprint money is getting
Great staff.
reduced?
I believe that is coming from the blueprint.
Thank you.
Okay, that's right.
Okay, at this time, I'm going to recognize Representative Dixon to speak to the bill.
Thank you, Mr. Thank you, members. First of all, Chris, Saunders, and Jennifer, thank you so much. Members, they've been working for 6 months on this kind of stuff, and we've all, everybody in here has praised our staff from one time or other. I just don't understand how they get things as accurate as they do with as much as we throw at them on a constant basis. My remarks are going to be in general and not really specific. The concept here, as many of you may remember, when the Senate passed their budget, they had $250 million in the budget for disaster relief across the state. We in the House leadership, had rather not have that disaster in the budget, but a different vehicle. So that explains why the disaster money is in this. The Senate, as most of you know, yesterday passed their version of the Farm Act. In the House, we were not sure when that would happen. And so a couple of days ago, we constructed a pathway that we felt would be workable to get the disaster money that is involved in this bill out before we apparently go home next week. The $20 million that Representative Harrison referred to is necessary. It will pull down $80 million from the feds to handle flood mitigation work, clearing, debris removal, river clean out for the Lumber River area. I don't know of anything more important down east than what that provision would do. So the $20 million there, and Representative Jones, Majority Leader Jones, will have more to say about that. There is in this bill $142 million for statewide disaster crop payments. This is irregardless of the event that necessitated the disaster. Any qualified disaster that took place in 2024, wherever it was in the state of North Carolina, this is additional disaster money for those. That application process, which is another reason that we were trying to get a vehicle that would move relatively quick, Commissioner Troxler in the Department of Agriculture has received almost 9,000 applications. If this is enacted in a timely manner, there will not have to be another application program. This will suffice. The funds will be distributed based on verifiable losses by commodity. There is only one weighted part of the distribution system, and I'll explain what weighted is. For example, our friends in the mountains cannot get insurance on Christmas trees. There are certain other nursery products that we can't get federal crop insurance on. So the last round that we did disaster funding, a lot of people outside of the Department of Agriculture worked on a formula of distribution. And I can tell you it is blind. It is a blind type of process. There were 0 complaints with the last round of funding that we did under these circumstances. I'll give you the simplest example that I can give you. The losses, let's say, with corn. You can get federal crop insurance on corn. Most farmers insure that for 40 to 65% of what their average production is. The department assumes an insurance rate of 60%. When the actual loss is known and we see what the insurance paid, that leaves an uninsured loss remaining. These funds, as the funds were in the past, will be distributed based on that uninsured loss that remains, weighted to cover Christmas trees and some things that you can't get insurance on. That is, in my estimation, one of the most vital parts of this legislation, this proposed legislation. To date, we have done very, very little for our row crop farmers. Some of these farmers started out 2024. Wheat is one of the last things that's harvested, one of the first things that's planted. Some of these losses occurred in January, February, and March of 2024. That drought was immediately followed by flooding, and then Hurricane Debbie, and then other factors. And so I think timely distributions of any funds that we would get out there is important. How did we come up with the $142 million? Over the last several weeks, I've been talking to the full chairs. And rather than go into the grocery store with an empty grocery cart and put what I think I need and what I think I want, and then get to the cash register and find out I don't have enough money to pay for it, I took the opposite approach. What I tried to find out is how much the full chairs thought that we could afford to put in this. We all know what the forecasts are, 26, 27. I have a lot of admiration for our full chairs and the tremendous job that they have. I don't think anybody in here wants to furlough teachers again. I don't think anybody in here wants to send out revisions. We're going to get criticized when we end up with a significant amount of money in surplus and why we didn't spend it. I've just stated the 2 main reasons that I'm concerned. So as they looked at the money available, they came back with that figure for me. that they were comfortable with me putting forward. So that gives you some of the background noise, certainly not the details. But we'll stand for any question, Mr. Chairman. I understand that there are amendments. We will deal with each of those amendments as they come around, and we'll take that, Mr. Chair, in any order that you want to. If there's any other members of the committee that would like to be recognized at this time, I would suggest that you do that.
Yes, sir. Before we start taking the amendments, we'll talk a little bit on what we do have that we can maybe get along with. So right now, is there anybody that has any questions, like to make a statement on the bill as it is right this second? Representative Harrison, please be brief.
Yes, I have two questions for the bill sponsor, and thank you. I appreciate your work on this, Representative Dixon. The questions that I asked the staff that they couldn't speak to the reason why, and I wanted to ask about that provision about no special use permits for farmland. Now I can't find what section that's in.
While you're looking, I need to take care of some housekeeping. This is a PCS come before us. Representative Dixon has presented the PCS with no objection. We will hear the PCS and allow staff to make technical corrections as we go along in this. All that being said, hear no objection. All right, go ahead. It's a series of questions, Representative Dixon.
Just to, Section 3, on page 2, allow denial of special use permits for negative impact on agricultural production. I was just trying to figure out what the purpose of that is. I wonder it appears to allow for the prohibition of solar panels on farmland, but I can't say that with any special knowledge. I just didn't know if you had if this was your provision, or if you could speak to what it applies to. Is there an issue?
I've had zero contact that this has anything to do with solar panels. The language there, Section 3, would allow a Board of Adjustment, Planning Board, or Governing Board to deny a special use permit for a property that is owned by a business entity that has owned the property for less than 3 years, on the basis that the proposed land use will negatively impact agriculture production within the local government's jurisdiction. This would not apply where the primary purpose of the proposed land use is the construction of single-family dwellings or 2, 3, or 4-family dwellings. Other than that, related to single-family or 4-family dwellings, this would allow anything that is considered negatively impacting agriculture production within that jurisdiction to be denied. That could be McDonald's, that could be driving range for golfing, that could certainly be any other type of structure that those adjustment boards and planning boards, in their wisdom of their locality, would impede the opportunity for agricultural production.
Thank you, thank you, Representative Dixon. I think that makes sense. I guess I would have thought that they already had that authority, but I guess this is clarifying it. And I know there's some changes made in the 90s about local board control over what can happen on agricultural land. So thank you for that. The other question I asked Mr. Saunders about was the APA exemption on page 11, section 20. I was trying to figure out, so this is, it's an APA exemption for modernizing wastewater permitting, and it looks, I don't know, is it to a specific situation, or is this a area where we've had problems? I was just trying, if you had any insight on what, sometimes just by looking at the statute, it's hard to tell what the impact will be. If you have any insight on that?
Is that page 8?
Well, it's page 11 on the page I'm looking at. It's section 20. I don't know, I printed this out this morning. Section 20, page 11, line 48.
That would exempt the rules adopted by the EMC after receiving approval from US EPA from 10 letters of objection and legislative review process in the Administrative Procedure Act, which means that the way I'm interpreting that is that they're exempted from the 10 letters. The way I'm reading it, Mr. Saunders might review it, from that Administrative Procedure Act. That in no way, I think, covers your question.
Staff, would you like to comment?
Thank you, Mr. Chairman. Jennifer McGinnis, Legislative Analysis. Yes, Representative Harrison, there was some language run in the budget last year that, well, it ended up in another bill the last night of session, but required the EMC and DEQ to develop specific rules. The shorthand was highly treated wastewater.
I remember.
Yeah. And then propose those draft rules up to US EPA for approval. And then when they came back to the department, presuming US EPA approved, then DEQ and EMC would have to take those approved rules to rulemaking within 20 days. And this would then eliminate the 10 letters of objection part of the rulemaking process.
Thank you. And Mr. Chair, I would be happy speaking to Section 17, but I think there's an amendment on it, so I'm going to wait, and thanks. I appreciate it.
All right, Representative Brody.
Thank you, Mr. Chair. It's basically on the same thing, 20A. If staff could, I think Jennifer just mentioned highly treated wastewater. That was something that I was working on at that time, right? But what was, why was this needed, or why is this perceived to be needed? Because in the industry that I'm in, the 10 letters of objection are just common to stop a lot of the rules and force them into the General Assembly to decide.
Go ahead, staff.
Mr. Chair,
Yes, sir.
I don't necessarily think that that's I don't think that question is for her. I think it would be for me, Representative Brody.
Okay, that's fine.
Somebody
sir.
in the Senate, some reason in the Senate, this was developed in the Senate, and we've inherited it.
Thank you, Mr. Chairman.
Anything further? All right. Representative Jeffries?
Thank you.
Jeffers, excuse me.
I just wanted to speak a little bit to what Representative Harrison asked about around the denial of the special use permit. As a former county commissioner, we would act as a quasi-judicial board. It was almost like a court. Everyone that had to speak at a public hearing had to be sworn in, and there were certain findings of fact that you had to utilize in order to deny or something. I think this is just adding impact to agricultural land to those reasons that you can find fact to deny a permit.
Thank you, sir. Anybody else? We're going to take, I'm sorry, Representative Lofton.
Thank you, Mr. Chair. Just a follow-up question along the lines of what Representative Jeffers and Harrison were asking about. Is there anything that defines what it means to interfere with agricultural production? And is it interfering with another property's use as agriculture, or is it enough if the land had been used for agriculture but then would shift to another use that in and of itself could be deemed a reduction in agricultural production?
Is that directed at staff?
Either the sponsor or the
Sponsor, would
staff.
you, staff, if you would, it's been deferred to you. Could you respond?
Thank you, Mr. Chair. Chris Saunders, Legislative Analysis. Representative Lawton, it's not defined in here. I think it would be in the discretion of the local government as to whether there was a negative impact on agricultural production. I think that could be interpreted to mean production on the land that was the subject of the special use permit application, or potentially neighboring properties as well. I mean, it's, as long as it's located within the county or the jurisdiction of the local government.
All right. If the committee would allow me, Christine Leggett with fiscal staff, I think there was a question asked earlier about the $20 million and some of the things, and I know you know the answers, hon.
Thank you, Mr. Chair. Christine Leggett, Fiscal Research. Representative Harrison, you asked earlier about where the $20 million was coming from for the Lumber River stuff. That is coming from the $96 million that was appropriated in the 2021 budget for stream debris removal related to the blueprint. So it's from that $96 million pot, not the $20 million that was appropriated to EQ for the blueprint.
All right. I think now, is there any further questions for Representative Dixon? Seeing none, I think now we will go ahead and start taking some of the amendments. Once we have all the amendments done, and each amendment, I will ask if anybody, after committees gets their questions, if anybody in the audience wants to speak to any amendment per se. Then at the end, I will open up public comment. All this is 1 minute at a time, so have your words put together, be ready to speak on the bill once all the amendments have been passed. Okay? Does everybody understand how we're going to play the game to a point? I hope so. All right. Representative, do you have anything further you'd like to state at this time?
No, sir. Thank you,
All
Mr.
right,
Chair.
thank you. Thank you. All right. At this time, I think we have Representative Penny is going to put forth Amendment S401-4TQ-78, version 3.
Thank you, Mr. Chair. Glad you've got to say all that.
Yep.
This actually goes back,
They are on the committee website. I hope everybody can find it. If not, refresh. Excuse me, sir. Go ahead.
okay, we're here talking about agriculture, but believe it or not, in a
Microphone.
I got it on.
You can get closer.
All right, I'll get closer. On page 9 of the bill, it's entitled Reduced Penalty for Certain Shellfish Aquaculture Violations. So this is to amend the statewide study on shellfish aquaculture leasing and current moratoriums on shellfish leasing. This passed the House already 110 to nothing. It's ended up over in a Senate bill and it's back in this bill. And the two key points is the effectiveness of existing regulations and permitting governing shellfish aquaculture leases, and recommendations for a statewide framework on the regulation and permitting of shellfish aquaculture that benefits the industry and the state while mitigating conflicts with users of public trust waters. That's the gist of the amendment.
All right. Any questions for Representative Penny on this amendment?
Mr. Chair,
Yes, sir. Representative Dixon, you recognize.
I would ask you to support this amendment.
I will call on you for a motion at an appropriate time then. Any other questions on this? If not, Representative Dixon, would you have a motion?
Yes, sir. I move that we approve the amendment that he just introduced.
Yes, will there be any public comment on this amendment? Any public comment? Seeing none. All those in favor of this amendment signify by saying aye. Aye. All those opposed, like sign. All right, ayes of the chair, the ayes have it. The amendment passes. All right. Representative Gillespie, we're to see or hear S401-ATC-17, version 2.
Thank you, Mr. Chairman. This amendment is language that we've all seen before. This is the sawmill language. We felt like that if sawmills isn't agriculture, I don't know what agriculture is, so it seemed like a good place for it. I'd ask for your support. Thank you.
All right. Any questions from the committee?
Mr. Chair,
Yes, sir.
if I'm not mistaken, that bill passed almost unanimously and is in the Senate, so I would ask you to support this amendment.
All right. At a motion at appropriate time. Any other questions? Anybody wish to speak on this in the audience? Seeing nobody making a move, I'll look to Representative Dixon for a motion.
I move that we give a favorable report to the amendment that Representative Gillespie just introduced.
All right. There's a motion on the floor. All those in favor signify by saying aye. Aye. All those opposed, like sign. Ayes have it. Motion does carry. Passes. All right. And I guess I've got two, so. Representative Penny, if you'd come and chair at this moment in time, I'll steal your seat. There's the titles.
Okay. I really appreciate that.
I'm gonna take them back from you as soon as you say it.
All right, good deal. The first amendment that Representative McNeely has got is S 401-ATQF-72, version 2. Require approval from county commissioners for annexation of certain property.
Thank you, Mr. Chairman. This bill has left the House Ag unanimously. It's also left, I think, the next bill it had to go to was reg reform. So it basically states what it has when it was here. Got a unanimous vote on both those. I think it falls in very well with what we're trying to do and preserve farmland. I stand for any questions.
Representative Moss.
Representative McNeely, reading this one, I don't remember voting for this, and I may have, but I don't think so. But it just seems like we're creating more hoops for landowners and their property rights that actually own the land. Now we're going to have the Board of Commissioners sign off on maybe an annexation that a municipality is going to do with a landowner. I'm just I'm asking, why was this created? I think I know the answer, to preserve farmland, or, I mean.
Well, what this will allow, basically, what we find a lot of times, especially, and I put it in, it's for 150,000 or more population counties, that they keep going farther and farther out, finding cheaper land to try to go ahead and annex. And next thing you know, we're having to build schools, or the schools are overcrowded, and then the bonds are having to done. So this, in a way, allows us to interfill the city and hopefully preserve some of the farmland till the whole ETJ moves out to it. This is going outside of city limits and outside of ETJ. So this helps a little bit, I feel like, in planning better and less sprawl.
Representative Ager.
Thank you, Mr. Chair. And just, so this would be for every county with more than 150,000 people in it, that if a town wanted to annex something, they couldn't do it unless the county commission approved?
No, that's not true. They still can.
Okay.
They'll have to make the adjustment on what it takes to put the school back into 100% capacity if it's over. So it can still happen. It's just they'll have to figure out how they're going to do it and work with the county.
Any other questions?
Mr. Chair.
Representative Dixon.
Representative McNeely, the money part originally is not in this, correct?
Correct. It's gone.
Mr. Chair.
Representative Dixon.
I would recommend we approve this proposed amendment.
All those in favor, Representative Brody.
Thank you, Mr. Chair. And Representative McNeely, can you give me an idea what kind of solutions would be, I guess, approved or whatever to equalize this so-called the school thing? Just briefly, I'm trying to imagine what that'd be, and unfortunately, I can't unless somebody's going to be paying some money. And if you have the situation where the school is full anyways, does that mean that because you can't mitigate that, then you can't sell that?
Well, you can mitigate it. It'll be up to the city to decide if they want to still do the annexation. So they'll have a choice in this, and they have a path forward. But this also, right now, county commissioners do not have a say in annexation, so any piece of property can happen at any place at any given time without any planning or looking at the county planning. So I'm hoping this will make the cities and the counties more work together in their planning and grow more uniformly. Right now, I see in my county especially sprawl. They're going here, they're going there, just wherever they happens to find something, and it's making for such overburden on roads, rural roads that shouldn't have 500, 600 homes to a point, or shouldn't be too far out with the sewer lines. Every time they run their sewer lines farther, it diminishes their sewer capacity, not just from the homes, but the ability. So this, I hope, will help them do interfield better inside the city limits or the ETJ. That's what we envision city limits and ETJ for.
Representative Brody, follow up.
No, thank you.
Representative Jeffers.
Thank you. For a question, would it allow, for those cities and counties that work well together, would it allow the city to exempt not the city, but allow the county to exempt the city from paying that? Let's say the county wants to go ahead and continue funding and not from the city, would allow them to do that?
Yeah, it basically gives the county commissioners the choice whether they say yes or no. They can say yes and there is nothing. If they say no and the city still wants to pursue, this does not stop them. So this does not stop anybody from developing. That's the beauty of it. But it does help make things work better, and I think it'll be a whole lot more cohesive.
Representative Moss.
Representative McNeely, one more last question, and I hate to pester you about it, but it's hard for me to wrap my mind around exactly what may be going on in your county. Because when I think of commissioners and city councils working together, sometimes that's almost impossible. But if someone's trying to sell some property and it's going to be annexed in by a municipality and the schools really can't handle it, it's going to put someone in a position where they're going to probably spend millions of dollars to build another school, which we all know what that's going to probably end up doing, making the sale not possible. So I'm trying to see exactly where you're coming from when you're saying that they can work together and this will make an easier path, because here in the last 4 or 5 years, we've tried to make things easier for building affordable homes, but it seems like this would be adding some kind of loophole or an obstacle course for somebody to actually do something if they chose to build on that land.
Well, I actually think this will help with affordable housing, because this will be able to be used in areas where in the city limits you can have increased density. Where in my county, it's 2 houses per acre if everything works perfectly in perks. This way it'll allow them to go ahead and make sure they do the inner fill inside the city limits. Like I said, the big thing that we have going on is sprawl, and it looks like a hopscotch pad. You have a piece of land here, and once the sewer gets there, then another piece connects to it, then another piece, and next thing you know, you're 3 miles outside of the ETJ of that city with all of a sudden with annexed property. And there's no planning involved in that. The cities walk away pretty much with the sewer and water tap fees. They're making money right off the get-go, where all the emphasis is put then on county roads and on county issues that they didn't see coming, because they hadn't planned this in their land plan to have that kind of density out there. Once it gets annexed, then the density increases out into the country.
Was there anyone from the public that was signed up to speak on this? Not seeing one. I see Representative Dixon's light still on.
Yep. I would suggest that we approve this amendment as presented by Representative McNeely. I don't remember the numbers, so you can repeat those.
Representative McNeely, you've got the number.
I do. 401-ATQF-72, version 2.
You've heard the motion. All those in favor will say aye. Aye. All those opposed? The ayes have it. The ayes have it, and the motion is approved. The next amendment before us is S 401-AR1-77, version 1, authorize use of certain subsurface dispersal products for wastewater storage and dispersal in traffic-related areas under private option permits. That was a mouthful.
That was.
I hope the bill's a lot simpler.
It really is, in my opinion. Basically what this does, it's allowing some septic, sub-water stuff to be able to have land. Basically the old saying, hey, don't go out there and park where my septic tank is, you'll fall in. You've probably heard that or whatever. Well, this allows basically these approved products from DEQ to be used where you can actually, I ain't gonna say you can build on it, but you can use the area where your septic field is, far as if you wanted to make a road through to go to another piece of your property or whatever, because of the advanced technology of this. And actually I have Nathan Honecker back there that I hope will speak on this. He is the expert.
Thank you, Mr. Chairman and Representative McNeely and members of the committee. Nathan Honecker, we represent T&J Panel that makes one of these on-site wastewater treatment systems. Representative McNeely described this very well. All this does is gives property owners another option for land use by allowing that area of property where the wastewater treatment system's located to be underneath a driveway or another impervious surface. An engineer has to sign off on this. There's precedent for this being done in this context with an engineer's approval in North Carolina, but there's no specific law or rule on the books. And so thank you for bringing this forward, and I encourage your support.
Thank you. I think Representative Harrison, did you have your hand up?
I'm sorry, I'm having trouble finding some of these amendments. Could you just repeat the first numbers for that?
The first ain't gonna help you, but the last, ARI-77V1.
Got it.
Okay. This actually was this was an amendment made to the Senate Farm Act. I know we don't want to talk about that, he who shall not be named, or it who shall not be named, but it's actually a very good amendment.
Seeing no other hands, Representative Dixon's recognized.
Vote your conscience.
I take it as a motion.
I think that was a motion. Representative Bettler, I see you got your.
Yeah, I just had a question. I don't know all that much about septic systems, but I always thought it was that water can seep into a septic system, right? Sometimes when they get old and they absorb water from around them. But is it a good idea to put impervious coverings over it? I mean, I don't quite understand why you would want to do that, just for convenience, to be able to drive or to?
I'm not an expert on this either. I do know where it goes once it leaves the house. So that's about as good as I am. But I do know that there's newer technology all the time, and this is approved technology that they're allowing through engineering to be able to take a next step. There's always that one side of your yard where you're always like, I can't go there, I can't do it. They made me put in something that looked like a city septic system from my house when I did it. And my whole side yard, I can't do a thing there. I'm not supposed to drive over or whatever. This would allow me to get to the back of my house if I had this system in. I have to go through the woods and come a back way because I can't go around the grass part of my yard because I don't want to get into my septic field.
Just a quick follow-up. So this is for just a specific type of septic system that is stronger,
Yes,
more
ma'am.
resilient. So an 18-wheeler is not going to crush this thing, or?
It's a concrete trench style septic system.
Okay, thank you.
Representative Sam Wofford, and I'm sure you are probably an expert on this, and I'm going to ask you you said you wanted to speak.
Representative Brody raised his hand after I did, so, but, that's about the only thing I am familiar with is sewer. And most of it does, like you say, some of it evaporates and some of it goes down, but this is a specialized system that's specifically made to do this, to allow it to where it's impervious on top, and it takes care of the rest of it underneath until it gets out of the impervious area.
Brody's next.
It works.
I knew the representative, my good friend Sam Wofford, was more than 50 miles from home, so I knew he was an expert. That's the reason I called on him. Representative Brody.
For a comment, please, on this. I just want to also mention that the lots are restricted, the size are restricted according to how well the system fits. But if you get closer to the coast, for example, they have sand and they have a area that they can use that is so limited, but the absorption is so good, so anywhere you go. So they use these type, or try to use these type, to go underneath driveways because there is no resistance to discharge underneath those, and it's a good product to do that. But like Nathan said, it's got to be engineered to qualify for the lot that you're using on.
Representative Gillespie is recognized.
Motion when appropriate.
Any other discussion? Seeing none, I think this is the appropriate time.
Move we have favorable to the amendment, second McNeely amendment.
All those in favor will say aye. Aye. Opposed? The ayes have it, and it is approved. And Representative McNeely, you're back up here with the gavel.
All right, best I can tell. The chair puts the committee at ease for 1 second. I think we have one more amendment. I'm going to check. ATQ 76V1. Representative Kidwell.
Thank you, Mr. Chairman. This amendment simply removes the section 17 on the bill, page 10, lines 34 through 49, which is giving some benefit to the chemical manufacturers and their liability. And this would simply take that out and leave the law as it stands.
Okay. Any questions for Representative Kidwell? Representative Harrison.
Well, just a quick comment, if that's okay, please.
Yes, ma'am.
Thank you. I did a little bit of research on this. Of course, like all of us, I've been hearing a lot from constituents and been following this issue, particularly as it relates to glyphosate. And that particular compound is used very frequently in agriculture. And some of the side effects of this are cancer, brain damage, Parkinson's, infertility, developmental harm to children. We've seen birth defects. It can be quite dangerous, and I think that this immunity provision here, this liability provision, is very problematic for the health of our constituents. So I encourage you to vote for this amendment, and thank you, Representative Kidwell, for running it.
Okay, I have Representative Penny and then Ager on deck.
I'm going to ask my colleagues to vote against this amendment. There's several things that really I don't think comes to play. Now, I understand that the chemical companies are large, and I understand about liability. I spent 50 years professionally in the agrochemical industry in the Carolinas and Virginia, so I know a little bit about what goes on. One of the things that's it's bothersome to me, when you go to Walmart, Kmart, if there's still a Kmart's, anywhere else, and you buy a chemical, there's a label on that container. If you go to a pesticide dealer, fertilizer dealer, and you go in and you buy a chemical, they're going to have an MSDS sheet. They're going to tell you what or how you need to apply that chemical, what your safety precautions, and what your apparel has to be to handle that chemical. They have to do that. They have MSDS manuals. Again, they have labels. And if you buy a restricted use chemical, first of all, you got to have a license. 50 years, I have a federal, state, public, and private pesticide license. So I spent a career knowing how to handle chemicals safely. My concern with what you're saying here is somebody puts on their their flip-flops, their Bermuda shorts, and their tank tops, gives them some chemicals, does not read the label, goes out and sprays it, and then there's a penalty for that. There's a reason why that person has chemical injury, because they did not read the label. Any container, from a small container to a large container, has a label, and you need to read the label. But the other impact, and I understand obviously chemical manufacturers have the deeper pockets, but if you stop to consider the impact on agriculture in North Carolina, if we don't have the chemicals, and I'm a farmer, I'll admit that, and I spray chemicals all the time, but if you thought about the economic impact on agriculture, if we don't have pesticides, insecticides, nematicides, weed killers to be able to produce a crop to feed us. And I look around here, I don't see too many people that's missed any meals in here. But they got to be safe. We all agree that they've got to be safe. But again, folks, I don't know how you legislate for people not reading the label.
Representative Ager, Moss on deck.
Thank you, Mr. Chair. And this may be a better question for staff. My question is, do we have, are there other industries that we give this kind of liability protection to? Do we give, the pharmaceutical industry this kind of liability protection, or any other industries where they go through a federal process and then we say, well, if you go through that federal process, then you get this same kind of liability? Is there anybody else?
I'm going to defer to staff. I could give you my personal opinion, but I think you'd want to have something better than that. Staff?
Thank you, Mr. Chair. Representative Ager, so the only two exceptions in 99B-5, which is this statute about failure to warn claims. The first is for open and obvious risks, or risks that are a matter of common knowledge. Those are kind of general exceptions. And then subsection C provides that no manufacturer or seller of a prescription drug shall be liable in a failure to warn claim or instruction directly to a consumer if an adequate warning or instruction has been provided to the physician or other legally authorized person who prescribes or dispenses that drug for the claimant, unless the U.S. FDA requires such direct consumer warning or instruction to accompany the product. So that's the only industry-specific exception in that statute.
Okay, that's helpful. And one more question, if I may, Mr.
Go ahead, sir.
Thank you very much. You know, you know, the pharmaceutical industry's got this one exception, and obviously, you know, when we're putting stuff in our bodies, that's a big deal. But you know, I guess my question, you know, really, and this is for, I'm not quite sure who it's for because we're bouncing around quite a bit here. But my question is really, you know, if a company, in normal circumstances, if a company creates a product, you know, what is the requirement that they stand by this product? It's just the failure to warn? That's all there is?
I'm going to go ahead and defer to Representative Penny. He
sounds
chooses to take that question.
Well, we've talked about FIFRA and we've talked about the EPA. And I've got a lot of experience on putting out chemicals before there was actually a brand name on the chemical. So there's years and years and years of research done on a particular chemical and the effect on the environment, whether that's human beings, plant life, wildlife, whatever. So it's gone through you don't just decide one day I'm going to have a new chemical and next year you've got it out on the market. It takes years to get there, and it takes millions and millions and millions of dollars of research, probably hundreds of millions of dollars of research to get a chemical to the marketplace. So to me, that's where the EPA, hopefully they're doing their job, but we're not talking about any liability back to the people who are supposedly making sure these chemicals are safe for us and telling us based on the label how we can apply and use that chemical and protect ourselves. I don't know if I've answered your question or not.
Just a quick comment, and I appreciate that, Representative
statement.
Just a quick comment. So, I mean, obviously FDA, they do their own research into these pharmaceuticals. And so when the government takes on that responsibility, they do their research, you know, then that liability protection makes some sense. What I worry about is with FIFRA, you know, the EPA doesn't actually do any of that research. They're just dependent upon the companies that sell these things to present them with research. And so I would ask you to approve this bill while we review better, or approve the amendment, since we really need to understand better how that impact.
Mr. Chair, could I respond?
Yes, sir. Go right ahead.
Thank you, Representative Ager. As I understand it, the rebuttable presumption is not legal immunity. What, in my discussions with people, and there'll be public comment that probably can use better language than a simple old turkey farmer can use. It simply says that if you're going to bring a liability lawsuit on XYZ company for failure to warn, you must produce evidence that proves they have failed to warn. The labeling process is very arduous for these labels. And I'm not going to belabor the point. I'll have more to say about this after public comment. But to have the proposal that you should put on there, this product causes cancer, after the EPA has spent thousands upon thousands of hours to produce these labels. And the proponents of this provision in here say that when you purchase one of these products and it's got the EPA labeling on it, it is a safe product if you use the product as you're supposed to. I'll share a few of the calls and a few of the texts later on that I've received on this. Most of them, and the last one I got was from New York, the one before that was from Kentucky, and the one before that was from Arizona. Why are you giving chemical companies immunity? That's offensive. If you oppose this, oppose it with facts, not scare tactics. Thank you, Mr. Chair.
All right, this time Representative Gillespie, and I'll do Butler, you're on deck.
Thank you, Mr. Chairman. I want to elaborate just a little bit further on some of Representative Dixon's comments. We started studying this bill and going through it and trying to understand every component of it. As you all know, it requires quite a bit of research. And when we start talking about failure to warn, which to me, failure to warn is a label. Maybe I oversimplify things, but and I want to read something to you about a label. It's an approved pesticide label must contain specific information. And I'm not going to read all of them to you because it'll probably put you to sleep, but read the main ones. Product identification, registration information, net contents, registration and establishment numbers, ingredients statement, hazard and precautionary statement, direction of use. Also says that those statements must not be false or misleading. First aid information has to be on that label. Restriction of use statement has to be on that label. An EPA evaluation has to be on that label. So, while I appreciate the amendment, I think that there's sufficient law in place to ensure, if we choose to read it, that we have been warned. Thank you, Mr. Chairman.
All right, and I'm going to have to put a pinch hitter in. Sorry, Representative Butler. I skipped over Representative Moss, and he had got me first. So go ahead, Ben. Excuse my language. Go ahead, Representative Moss.
Thank you, Mr. Chairman. Just one little quick comment and maybe a question for my friend there, Representative Penny. Looking at this, it says limit liability. That's what the section says. That's the title, limit liability. And I'm aware that there's warning labels on these chemicals because I've used some, not to the degree that some people in this room have. But I also realize that, I'm not an attorney. We have probably 100 of those in the General Assembly, but I'm not one of them. But if someone has a case, I'm sure an attorney has to agree to take that case before they go to one of these pesticide manufacturers or whatever the case may be. So I'm asking the question, why now, after all these years these chemicals have been out, that we're needed to step in and maybe sort of limit the liability? The warning labels are on there. If the people purchase the product and they distribute it in a manner that's not safe or in compliance with the label, then I think that should be a private matter between the attorneys for, I guess, the person and the attorneys for maybe the company that produces the product. So I'm just asking a question, basically. I mean, why are we having to step in and do something that may limit liability?
Thank you for
Representative Penny.
Thank you for the question. I'm going to defer that to staff because I did not come up with a labeling title on this portion of the bill.
Mr. Chair,
Anybody
Mr.
feels
Chair,
good?
Mr. Chair,
Yes.
could I respond briefly to
Yes, you
that?
can if you'd like, sir. Representative Dix is recognized.
Representative Moss, I believe your question was why now? Why now is because traveling litigators, out-of-state attorneys, going around the nation suing successful companies with the hope of settling. And there's been many, many settlements that have taken place into the millions of dollars. And what we're finding out now is that it's at the point to where the defendants are not willing to continue settling for the amount of money from these lawsuits. Down in Duplin County, just a few years ago, we experienced that with the lawsuits against our swine farmers. And we've been raising swine and hogs for a long time. So specifically, to answer your question of why now, the litigation is unbearable, and they need some relief. The word limit is in there, but it doesn't say immunity. It simply says if you are going to bring a lawsuit on failure to warn, bring your evidence with you. I'm not going to say a whole lot more about that. And a lot of this takes place in federal courts. When you visit my office the next time, I will show you evidence that deep that we were not allowed to bring into the courtroom. They are suppressing evidence. They're denying the opportunity to present your case. This is why, and this is just Old Turkey Farmer, to answer your question as to why now. If the company fails to warn, bring your evidence that shows that, and you can litigate them until the cows come home.
You want to follow up to staff, or what do you want to do, Representative Moss?
Well, I mean, I
make a
don't know
statement.
if the staff can add anything to it, but, you know, I mean, just one final statement. I mean, I see where they're coming from, but we live in a world of liabilities, and where do we draw the line? Who's going to be next to ask the General Assembly for maybe a little bit of limiting liabilities? And I understand these products are important to our farmers. They are. Nobody wants to go back to the methods we had before them, but in the same token, I just want to make sure everybody handles their situations in a private matter to where maybe it has been tried, maybe it's not working and that's why they're here. But I have a hard time with some of this wording in here, and that's why at this time I'm supporting the amendment, and everybody in here can vote their conscience. But it's nothing against anybody in this room. A lot of you know more than I do, you're farmers, but I just can't just give a company I don't know. I just don't feel like it's needed, in my opinion, and I'll close there.
All right. Representative Butler, and then Representative Kidwell. But since Representative Kidwell, before we take any kind of other thing, we've got public comment. So go ahead, Representative Butler. If you can, keep it brief.
I will, and thank you. I have to agree with Representative Moss. You know, this is for the trial courts, and we have no business putting our thumb on the scale here. People bring their evidence, they're represented by counsel on both sides, and the courts do their work. And yes, there have been enormous settlements, but you can't tell me that these companies aren't engaging in $1.8 billion settlements. DuPont, for example, is the one that did that. We're suffering with Camora's bad acts down my way, our water situation. So, you know, again, let's let the courts do the thing that they do. Let's not put our finger on the scale. And of course, I can tell you, I mean, evidence is required to win a case, and that is the way we should leave it. Thank you.
All right. Representative Kidwell.
Thank you, Mr. Chairman. Yeah, I don't even know where to begin on this. You know, first, I think most of you know I'm pretty much not a tree hugger. I don't get out there on these issues in most cases. I took a position on a PFAS bill because of the way the liability was going to be dealt with, and I didn't feel we should go backwards and hold somebody liable for something that was legal at that time. Here, it seems to me we're looking forward and saying, well, we're not going to hold a company liable, and that word is specifically in there for a situation. Why are we going to limit the ability of the courts to do this? And, you know, I'm 64 years old in a week, and I was raised in the time when they started putting lead in gasoline, and it was approved by the government. Found out that was bad for us. I was raised in a home where there was asbestos in the walls, on the pipes, and everything else. And then they found out that was bad for us. Yep. I was raised at a time when some of the companies were making products where people were dying from it, and the federal government allowed it, and the state governments allowed it, and waived liability, and it was bad for us. I was raised during Love Canal, when an entire area was shut down and people to this day cannot live there because it was polluted by chemicals. I was raised on the banks of the Passaic River in Passaic, New Jersey. Not a fish, frog, minnow, the flies wouldn't even land on it. Because of the chemicals in that water, it was rated one of the top, and I think arguably the top, most polluted river in the United States. No, I'm sorry, in the world. Okay? These were all chemicals and processes and procedures approved by our government. Teflon, there was a lawsuit on that. Not the use of it in the frying pans, but the fact of the manufacturing process and that it was killing people around the plant. And that was approved by the government. Food today, ladies and gentlemen. We're just finding out now, only because of RFK Jr., that a lot of the stuff they're feeding us, they know is no good for us. How do I know they know? My wife watches this show where they show you different foods from different countries and they let kids eat it, and the kids look at it and they say, why don't our Fruit Loops in the UK and Canada look the same as they do in the United States? And the reason is all the artificial dyes and colors that are used in the United States that other countries don't even allow, because they know it's no good for you, yet our federal government allows it. So to say that the government allows it, they have a label, they've approved it, means nothing to me. Why? I've said this on the floor of this House more than once, because I don't trust our government. That's why I'm here. Ladies and gentlemen, we don't need to limit the liability to a company if they're not doing something wrong, because the courts will flesh it out, because I do trust the courts somewhat more than I do the government. But to turn around and give them a liability waiver just out, and you know, we haven't done it for how long? These products been around how long? 30 years, 40 years?
A long time.
And now all of a sudden we have to go ahead and stick this into a bill and run it through to protect somebody. I don't know who. I don't know why. I just don't trust them. And I'll give you this last piece. Most recently, the government said, trust us, you can take this vaccine. And I can tell you from doctors I've spoken to, I can tell you from the Vaxxer reports online, or VAERS reports online, and I can tell you from people I've seen very close to me died because they took that product. But the government said it was okay. No, damn it, no.
Bad thing was you had a lot of your people with you not shaking their heads right then, but that's okay. All right, now we're going to take some public comment because this is at People's House. Marie Muller, and like I said, I'm sorry, but we are going to limit you to 1 minute, so be precise.
Yes, sir. Thank you, Chair. My name is Marie Mueller, and I am a Wake County resident. I was born and raised here, and I'm raising my children here as well. A few things I want to note that has been said today. We need to pull this from the bill. I've been working for 2 months with a grassroots community of just random strangers who met over at the Senate when this was trying to be passed. These products do not warn of long-term health risks. They, on the label, the EPA label, says, this is what you do if you get it in your eyes. This is what you do if you get it on your shoes or your clothing. Wash your eyes, go see a doctor. No long-term risks. No one is getting cancer, non-Hodgkin's lymphoma, Parkinson's, birth defects, developmental harm in one use. This is over a lot of time. When it comes to farmers using this, you are free to use this. I do not, but you are free. I want to say this one last thing. These chemicals are used on our playgrounds, school grounds, parks, everywhere. My kids do not consent to these chemicals being sprayed. They should be able to sue if they are.
Thank you, ma'am. Next, I have Stacy Sereno with North Carolina Farm Bureau. Looks like I have Mindy Sportsman on deck.
Thank you, Mr. Chairman. My name is Stacy Sereno. I represent North Carolina Farm Bureau, and we proudly represent the 40,000 North Carolina farmers from the mountains to the coast who grow everything from Christmas trees and apples to corn and soybeans. North Carolina Farm Bureau strongly supports Section 17 of this bill, and we would oppose the amendment to strip this provision out. North Carolina farmers suffer from litigation against pesticide manufacturers because they are the ones who stand the risk of losing access to the products that they have to grow their crops. Litigation and settlement costs are also passed along to the farmers, resulting in even higher input costs. Those costs don't go down. They just keep going up. I know that some farmers may see this as the pesticide company's problem, but the reality is that the threat to agriculture is much broader. 2 times higher input costs for farmers, double the food inflation for consumers, and near total reliance on foreign adversaries for a key agricultural input. Our organization strongly supports this provision and opposes the amendment. Thank you.
Thank you, ma'am. Mindy Sportsman. If you can, plow new ground, as we like to say in this committee, so go ahead.
Thank you. The only reason these companies have to pay damages is because there is true harm. There is science to back up the harm, and they have knowingly withheld this information from consumers. Otherwise, the lawsuits would not be able to be won. These products lack the appropriate warnings to warn consumers about the risk this exposure carries. Bayer and Monsanto have intentionally suppressed data and not updated their products' labels with this information. If they warned consumers of their products' health risks, they would not be liable in these lawsuits. Section 17 S401 will shield not just glyphosate and Bayer, but all 15,000 chemicals regulated under FIFRA and all future chemicals in this space, and all companies operating in this space, including Chinese military companies like ChemChina. Section 17 grants de facto immunity to all pesticide manufacturers, and it opens the door for dangerous chemicals to be brought to the market with de facto immunity. And the farmers can use their chemicals. We are not against farmers using their chemicals. That has been a moot point that is continuously being made. Everybody has the right to use what they want.
Thank you, ma'am. Thank you. All right, if it could, let me have, I guess it's Brandon Batten, and then Karen Raines is on deck.
Thank you, Mr. Chairman, members. My name is Brandon Batten, and I'm a 6th-generation farmer just down the road in Johnston County. Farming is hard enough when we have every tool available at our disposal and when everything goes perfectly. If we lose any of that, farming profitably becomes nearly impossible. This Section 17, I ask that you reject this amendment because, as you have heard, there is a lot of evidence. And I would just note that the LD50, which is a lethal dose to kill 50% of a population of glyphosate, is an order of magnitude less than caffeine. The research has been done. The label is the law. That is what we're held to as farmers. That is what the companies are held to through the rigorous process. If that's not good enough, then change the law to require the label to be updated. Thank you.
Thank you, sir. Karen Raines. and probably have Jimmy Thomas on deck.
Thank you for this opportunity to speak. I am in favor of the amendment and striking 17 on the basis of the fact that the labels do not provide, and the processes that they go through for those labels do not provide full and complete and accurate information. I have been a part of this group that has been opposing the Farm Bill, these sections of it, and there are noted seasoned immunologists who I've learned from, that they're just saying that one component, one ingredient is safe, and yet not covering the dangers of that ingredient interacting with other ingredients and how devastating the effects can be on someone's health. That's not complete.
Thank you, ma'am. If we could, Jimmy Thomas.
Hi, I'm Jimmy Thomas from Person County, Timberlake, North Carolina. I'm speaking on behalf of farmers across the state. For over 75 years, we've trusted the effort to regulate pesticides-based scientific standards. The system works. It ensures products are safe and effective, but that certainly is now under threat. Trial lawyers have weaponized junk science to sue manufacturers for glyphosate-based herbicides, tools farmers like me rely on every single season. These lawsuits don't just target companies, they target American agriculture. If we lose glyphosate, we lose a key that helps control weeds, protects yields, and keeps food affordable. The consequences: higher costs for farmers, which will mean higher food prices for consumers and reliance on foreign food supplies. It will also mean a dangerous reliance on China, who is the only country that manufactures glyphosate. This will not just bad for agriculture, it's a national security risk. Section 17 is simple. It affirms that the EPA-approved label is the law. It stops lawyers from second-guessing.
Thank you, sir. Next, I have Beth Sakaki, maybe. I hope I got that close. And looks like I have Peter Daniels on deck.
Hello, my name is Beth Sikoski, and I'm a co-founder of Heal NC and a state director for Stand for Health Freedom. We represent over 21,000 North Carolina citizens. I'm also speaking on behalf of my colleague, Diana Lightfoot, who is the director of North Carolina Physicians for Freedom. She couldn't be here today because of the short notice. Between our three organizations, we have numerous experts, including doctors, lawyers, scientists, and farmers, who would like to testify about this issue, but they were not given adequate time to be here. There are chemicals that are known to cause cancer and have been banned in Europe and beyond that do not include a warning on the label. The litigation is revealing fraud on behalf of these companies. They are not including the proper information on their label. The rebuttal is also a problem. It holds litigants to a higher standard than the companies must provide to the EPA. Why have we been given less than 24?
Thank you, ma'am. Thank you, sir.
Thank you, Mr. Chair, committee chairs, and my name is Peter Daniel Sr. I am chair of the NC Ag Partnership, a nonprofit that supports reasonable regulations and laws that help farmers, businesses, and rural communities thrive. Section 17, we support. I will build upon the comments that have already been made. This provides speed bumps and guardrails on these lawsuits, these frivolous lawsuits, the lawfare that is now becoming commonplace when different groups go outside of the legislative regulatory process and attack farming. And with that, I'll yield my time back to the committee. Thank you, sir.
Thank you, sir. It looks like I have Paulina Boronsky. Hey, it ain't bad. All right, and then on deck, Cameron Dawson.
First, it strips North Carolinians of the right to seek justice in court if they are harmed by toxic pesticides, even when the manufacturer knew the risk. Families suffering from cancer, birth defects, and long-term illnesses caused by pesticides exposure would be left with no legal recourse, simply because the chemical had an EPA-approved label. That's not justice, it's a corporate protectionism. Second, the EPA label is not a safety guarantee. It's widely known that the EPA relies heavily on the industry-submitted data. It does not test for long-term human health. Dangerous substances like glyphosate and paraquat were once approved by EPA, yet are now subject to lawsuit scientific concern in public health. And also, farms are not protected against the lawsuits, but you're going to protect the companies that manufacture them, but the farmers, they still can be sued because they're the ones that are using it.
Thank you, ma'am. After that, we will have Brian Wilson and Lisa Morissette. Go ahead, sir.
Thank you, Mr. Chairman, members of the committee. My name is Cameron Dawson. I am here on behalf of the North Carolina Department of Agriculture and Consumer Services. I rise today in support of Section 17 of Senate Bill 401 and would respectfully ask for you to oppose this amendment. The provision allows our farmers to maintain access to the products that allow them to be productive and profitable on their farms. As many of you have heard, American Farmland Trust ranks North Carolina number 2 in the possibility for farmland loss by the year 2040. Without these tools and additional increase in costs for North Carolina farmers, it is a real possibility that North Carolina finds its way to that top spot for farmland loss. With many farms across the state operating with razor-thin margins, increased costs and continued operational increases could be detrimental to those farms across the state. So again, I would respectfully ask for you to vote no on this amendment and allow our farmers to continue doing what they do best, continuing to add to North Carolina's #1 industry, which is agriculture and agribusiness.
Thank you, sir. Brian Wilson. And then, like I said, Elisa Morissette. I hope I'm pronouncing her first name right.
Good afternoon. My name is Brian Wilson. I'm a regenerative agriculture farmer in Alamance County, and I can assure you that I can grow food without chemicals. I'm a prior naval officer who was kicked out of service over COVID because I would not stand up and give or follow illegal orders from this government. All I've heard today, Mr. Dixon was talking about how he hated fear-mongering, but that's all I've heard from the other side. So I consider it hypocrisy if I'm going to be sat here today toxifying a planet for my children, being told that our food systems are going to collapse because we don't have chemicals. That's fear-mongering, and it suggests to me that you're barking up the wrong tree and not dealing with the right problems that you should be dealing with in our agricultural systems. Thank you.
Thank you.
Good afternoon. My name is Alyssa Morrissey, and I'm the Director of Regulatory Affairs at the North Carolina Chamber, and I am urging your support of Section 17. The provision reaffirms that the federal government already stringently regulates pesticide manufacturers through the Federal Insecticide, Fungicide, and Rodenticide Act. Under that law, manufacturers cannot warn a consumer about the risks associated with the pesticide if the federal government does not believe that risk exists. Section 17 recognizes that federal law already thoroughly governs product labels, and the notion of furthering a state-by-state patchwork of additional product liability standards is both unnecessary and untenable. Without this provision, North Carolina is opening a pathway for companies to be targeted by plaintiffs' attorneys for simply complying with federal law. The rigor of EPA requirements cannot be overstated. Attempts to undermine this will increase lawsuits and bigger pockets for plaintiffs' attorneys, but will not do anything for farmer safety. This provision protects an efficient food system, the rule of law, and crop tools. We ask for your support.
All right, I next have Charles Hall and then Nathan Honaker on deck.
Thank you, Mr. Chairman. Charles Hall, Executive Director of North Carolina Soybean Producers Association, representing all soy growers in the state of North Carolina. And we opposed this amendment that would strike Section 17. Fact, European farmers use glyphosate every day. I've worked on a European farm. I know this is a fact. Fact, as the previous speaker stated, a manufacturer cannot put a cannot put a warning label on a cannot put a warning about cancer risk on a pesticide label when EPA scientists themselves have concluded there is no risk of cancer. It's illegal under FIFRA for them to include such a warning. And a third and final fact, pesticides and other crop protection products are very, very slow to come to market. The reason that this situation is putting our farmers in a crunch is their crop protection opportunities are dwindling, not increasing. We don't see new products every year. We see new products once a decade, once every 20 years. When we crunch the manufacturers in the courtrooms, our farmers lose their opportunities. Thank you.
Thank you, sir. Nathan Honaker.
Thank you, Mr. Chairman, members of the committee. Nathan Honaker with Connect C. It's our privilege to represent the Agricultural Alliance of North Carolina, which is made up of the following members: Carolina Cotton Growers Cooperative, Cotton Producers Association, North Carolina Peanut Growers, North Carolina Sweet Potato Commission, North Carolina State Grange, North Carolina Soybean Producers Association, Nutrien, Bear Crop Sciences, Syngenta, North Carolina Egg Association, Mount Air Farms, Valent, BASF, the North Carolina Christmas Tree Association, the North Carolina Horse Council, and Crumpler Plastic Pipe Incorporated. Each of these individual members has an equal vote in our association, and they unanimously voted to support continuing to have Section 17 in the Farm Act. We believe this section strikes an appropriate balance between the public's interest in holding companies accountable for their products and the need to protect businesses from frivolous lawsuits and protect our #1 industry in North Carolina, which is agriculture. Thank you.
Thank you, sir. All right, we're going to close public comment. That's all we have right now. I'm going to allow each side, and I'm assuming Representative Dixon would like to speak on this, and I'll have one on the other side for closing, and then we're going to take a vote.
I'll speak last.
That'd be fine. Representative Kidwell, do you wish to speak, or somebody else will you defer to?
I'll defer to anybody else who wants it. Mr. Chairman, I believe I've said everything I have to say.
Okay. Representative Moss.
Thank you, Mr. Chairman. I'll make it brief because we've had a lot of information shared today. But one thing that I have found from both sides that it seems to be a federal issue. So my question is, why aren't we letting the federal government handle it? Second question is, what other states are trying to take these measures that will actually limit liability to an extent? I ask for everyone in this committee, just vote your conscience. At the end of the day, I'm pro-farming, and I do not like the way this reads or feels, so I have to do what's best for me and my constituents. I've had a lot of emails. They're not from California, they're not from Nevada, they're not from anywhere else but North Carolina, and specific to my district, a lot of them. So I'm here as a mouthpiece for my people, and I will have to vote my conscience, and I suggest everyone in this room do the same.
Representative Dixon.
Thank you, Mr. Chair. And my sentiment is identical with the last statement that Representative Moss made. I would never stand up here and ask anybody to vote against their conscience. That's why we're sent up here, is to vote our conscience. I'm going to just give a couple of closing remarks. I don't think that I will change anybody's mind. I think folks' minds are set where they're set. There's a research firm, Aimpoint, AIMPOINT Research, the Directions Group. I want to just share a couple of things there. And I would encourage you to go to that site. And this is relative to North Carolina. The negative effect for this would be if we can't use the herbicides and pesticides, the negative effects to the land and to the environment would wipe out the benefit of 36.48 million acres of forest land.
Hold tight.
The environmental benefits of being able to use glyphosate enable conservation practices on 53.4 million farm acres. 22% reduction in sediment loss. 19% reduction in water use for irrigation. 16% reduction in soil erosion from wind. 13% reduction in soil erosion from water. And I could stand up here a long time, which I'm not going to do, because I don't think any minds are going to be changed. We can't farm without chemicals. Representative Kidwell did a magnificent job of throwing out about a dozen rabbits that have nothing to do with the issue that we're talking about here. I don't know of any government that would approve what happened at Love Canal. People abuse it. Even this regulation here is going to be dependent upon how people do. So you've heard the testimony from the people out there. I'm ready for a vote.
All right. No further comment from there. We will get ready right now. I hope everybody understands that the Representative Kidwell's motion is to delete that section. I think it's 17. Am I correct? All right. So that's the motion. So
I ask people to vote against that.
Exactly. All right. And so all those in favor of the motion signify by saying aye. Aye. All those opposed to the motion signify by saying aye. Aye. And the ayes in the ears of the chair.
Sir, you said aye twice.
Well, excuse me then. All those opposed, nay.
Nay.
Nay. And the ayes in the ears of the chair, I hear more nays.
Division.
Can you abstain?
I'm sorry, sir, yes. Division.
2, 3, 4, 5, 6, 7. All right.
Aye, stand up, please.
I guess we're going to do a roll call then.
Representatives Ager? Yes. Ager, aye. Representatives Alston?
Aye.
Austin, aye. Balcom? Aye. Balcom, aye. Biggs?
Aye.
Biggs, aye. Brisson? No. Brisson, no. Brody? Aye. Brody, aye. Brown?
Aye.
Brown, aye. Butler? Aye. Butler, aye. Crawford?
Aye.
Crawford, aye. Davis? Yes. Davis, aye. Edens? No. Edens, no. Greenfield? Aye. Greenfield, aye. Hall?
No.
Hall, no. Harrison? Aye. Harrison, aye. Humphrey?
No.
Humphrey, no. Honeycutt? No. Honeycutt, no. Jackson?
Aye.
Sorry, Jackson again, I'm sorry. Jackson, Jackson, aye. Jeffers?
No.
Jeffers, no. Kidwell? Aye. Kidwell, aye. Lofton? Aye. Lofton, aye. Majid?
No.
Majid, no. Moss? Aye. Moss, aye. Pickett? Yes. Pickett, aye. Quick?
Aye.
Quick, aye. Reeves? Aye. Reeves, aye. Strickland?
No.
Strickland, no. Watford?
No.
Watford, no. Jones? Jones, aye. Setzer?
Aye.
Setzer, aye. Tyson? Tyson, I. Dixon?
No.
Dixon, no. Gillespie?
No.
Gillespie, no. McNeely?
No.
No. Penny?
No.
Penny, no.
Motion carries 21-13. Now, we will move on to the Farm Act with the amendments either put in or the parts that took out. Representative
Mr.
Dixon?
Chair,
Yes, sir.
I move that we recess.
Okay. We'll take a recess at this time, 10 minutes. So we'll be back at 6:15. If we could, let's all get back to our seats.
Mr. Chair,
Yes, sir. I'll be ready to recognize you in 1 second. Everybody see? Representative Dixon,
thank
recognize
Mr.
you.
Chair. Mr. Chair, I withdraw the bill.
Okay. At this point, the bill has been withdrawn. Committee is adjourned.